Good morning, everyone, and welcome to today's webinar. I am Chris McCauley, Benefits Attorney with ProBenefits. Today's webinar is a refresher on mid-year Section 125 qualifying events. Today's webinar is also our debut of a new webinar format, and that is a 15-minute mini webinar on a specific compliance topic. And as always, a copy of the slides and recording will be available to you after the presentation. We will email that to you. The mini webinar is a new format we are debuting for 2015. We will sprinkle that in with some of our regular length webinars for the year. As always, you can ask questions in the question box on the right control panel. Because this is a mini webinar, we're going to answer all questions today written. We'll answer those in writing, but you can still ask them on the right. Since we are only I'm going to do my best to keep this to 15 minutes. I'm going to jump right into the presentation. And we're going to start with the basic idea that anything of value that an employee provides an employer provides to their employees is taxable unless there is an exception in the IRS code. And Section 125 is an exception to that general rule. Section 125 of the IRS codes allows employees to pay for certain benefits pre-tax, such as medical insurance, dental insurance, vision, long-term disability, life. They can pay for those benefits pre-tax as long as a number of conditions are met. And one of the main conditions, one of the most important, is the irrevocable election rule. And that rule basically says that an employee's election to participate or not participate in the 125 plan cannot be changed during the coverage period, generally the plan year, unless that employee experiences a qualifying event that permits a change. So the employee makes an election and elects particular benefits and elects to pre-tax those benefits during the plan's open enrollment, and that election must stay in force throughout the plan year. And only if the employee experiences a qualifying event can they make a change during the middle of the plan year. Now, as we go through we're going to talk about the qualifying events that are allowed by the IRS, but the qualifying events that are allowed are permissive. Plans are not required to allow any changes during the middle of the plan year. Even though the IRS allows an employee to make a change, plans are not required to allow employees to do so. However, most plans do allow the employees to make all changes permitted by the IRS, generally because that makes sense and that's the most participant-friendly way to administer the plan. Participant changes that the plan wants to allow should be included in the plan legal documents. Any legal documents, any 125 documents drafted by ProBenefits already includes all the changes permitted by the IRS. So basically that is a background to frame our discussion today about when can an employee make a mid-year change to a 125 election. And there's several different requirements, but the three main requirements that must be met in order to allow an employee to make a mid-year change is first, the employee must experience an IRS-permitted qualifying event. Second, the change that the employee is requesting to make must be consistent with that qualifying event. And finally, as we already said the plan legal documents must permit the change as well. So as we move on to the next slide, we're going to touch on that first requirement, and that requirement being that an IRS-approved qualifying event must occur. So what exactly are the qualifying events? And here I've listed some of the most common qualifying events, and I'll go through and touch on them briefly. The first type of event that could be a qualifying event for an employee is a change in status, and that is, there are several scenarios that fall under change of status, one being gaining or losing a spouse or dependent, and generally that occurs by birth, by adoption, marriage, divorce, or death. Those are the type of events generally that fall under gaining or losing a spouse or dependent. Also, changes in employment status of an employee, spouse, or dependent that affect eligibility. So this would be a scenario where perhaps your spouse wasn't working and is now working and is now eligible for benefits under their new employer. Or another scenario would be a spouse or a dependent or the employee as well that was working 15 hours and wasn't eligible for benefits under their employer's plan, but now they're moving to full-time. Maybe they've been bumped up to 35 hours and now they are eligible for benefits. An event causing a dependent to satisfy or cease to satisfy eligibility requirements. Generally, the most common event here is a dependent that ages out of the plan. They were eligible at 25. They turned 26 and they're no longer eligible. A change in a place of residence potentially is a qualifying event. Certain cost changes to the plan. It's beyond the scope of our discussion today, but there are certain differences between an insignificant change in cost and a significant change in cost. So just know the changes that are allowed could depend on whether the change is considered insignificant or significant. A change in the benefits being offered, significant change in benefits. Also a change in coverage under an employer's cafeteria plan or open enrollment. This is a common qualifying event. If I have a spouse that is going through open enrollment, then potentially I can make a change under my own plan if I'm being added to the spouse's plan during open enrollment. HIPAA special enrollment rights, another event. Also court judgments, decrees or orders, Medicare entitlement, and also FMLA leaves of absences are all potential qualifying events approved by the IRS. And the list of qualifying events had remained recently static for a long period of time, but a newly approved qualifying event was added by the IRS in September. And that's a qualifying event for gaining marketplace coverage. An employee that has elected group medical coverage and subsequently enrolls on the marketplace or the exchanges can now drop group medical coverage. The marketplace was introduced last year in 2014, and there were some issues with employees that were covered by their group plan wanted to move to the marketplace in the middle of their group plan year, but there was no qualifying event that allowed that particular change. And the IRS has added the new qualifying event to allow a change in that scenario. In order to take advantage of this particular qualifying event, the employee must enroll in marketplace. It can't just be the dependent going to the marketplace or a spouse going to a marketplace. It is the employee himself or herself who must go to the marketplace. And if a spouse and dependent are going as well, then they can all drop coverage. But the most important part is that an employee is covered by the group plan, moves to the marketplace, and can drop coverage under the group plan during the middle of the plan year. So we talked about some common qualifying events. Here are some common occurrences that are not qualifying events. Financial hardship is one we often see where potentially an employee and a spouse are covered by the employee's plan, and the spouse loses employment. The spouse wasn't covered under their employer plan, so they didn't lose coverage, but now there is less income in the household, so there's some financial hardship. Generally, unfortunately, that is not a qualifying event that allows a change, nor does a change in medical condition or generally legal separation is another common occurrence that we see that isn't a qualifying event. Divorce, yes, but legal separation, no. So as we move on to the next slide, we've talked about the first major requirement, which is there must be a qualifying event. The second major requirement is the consistency rule, and I think this is more important, or if there's something that you take away from today's webinar, I think this would be the most important thing. And the consistency rule basically says that just because there is a qualifying event, that does not mean that the employee is allowed to make whatever change they are requesting. The change that they are requesting must match the event that is actually occurring. So the consistency rule says that the changes that is requested by the employee must be consistent with the qualifying event being relied upon to make the change. The IRS guidance says the change must be on account of and correspond with the event. I don't really think that that particular phrase is much help to describe what a consistent change is, but what is helpful is that most of the guidance regarding the meaning of this particular requirement comes from certain examples provided in the regulations. So to figure out what this rule means, we look at the examples provided in the guidance. And one common consistency example that I wanted to point out to maybe help show how the consistency rule works is as follows. An employee has medical coverage under the employer's plan, and that employee's spouse has medical coverage under the spouse's employer's plan. So an employee and a spouse, each with coverage under their own employer's plan. The spouse's employment ends, and the spouse loses medical coverage. So the question is, can an employee make a change to his or her medical election, and if so, what change is permitted since the spouse lost coverage? The spouse lost coverage because their employment terminated. So as we talked about before, that is a qualifying event. So the question is, what change can be made? And in this particular scenario, since the spouse lost coverage, the employee would be permitted to add coverage for the spouse. So the consistent change would be that the employee adds coverage for the spouse who lost coverage. So the employee would add coverage for the spouse under the employee's plan. What is not consistent is what often happens in this scenario. Oftentimes, the employee wants to drop his or her own coverage once the spouse loses their job because and this is fair, the employee says, I don't have the same income I had when my spouse was employed. I can no longer afford to pay my medical coverage. But unfortunately, the consistency rule would not allow the employee to drop coverage in this scenario. This is a broad generalization, but the consistency rule basically says that in general, if someone is losing coverage, then the consistent change would be to add coverage somewhere else. Or if someone is gaining coverage, the consistent change would be to drop coverage somewhere else. So that's a broad generalization, but just something to help you understand the consistency rule a little bit more. The consistency rule also affects the benefit options that can be changed. So just for example, a loss of dental coverage somewhere would not allow the addition of vision coverage. If you lose dental coverage, a consistent change would be to add that same coverage somewhere else. And so this is the consistency rule. We'll talk about it again just briefly here. I wanted to move to analyzing qualifying events. So if you're an administrator and an employee comes to you and wants to make an election change, they've experienced a qualifying event. What steps should you take as the administrator to figure out whether the event would allow a particular change? And obviously the first one is to determine whether a qualifying event occurred, whether the employee experienced the qualifying event, which we've talked about the common qualifying events. Second, do the plan legal documents permit a change for this reason? We've also discussed that requirement, as well as the third question as well. Is the change requested consistent with the qualifying event that has occurred? Once you go through those main three requirements, you then want to move on to get documentation that the event actually occurred. Generally, an employee certification will be sufficient. So if the employee signs a document saying what event occurred and saying that it actually did occur, that generally that is sufficient documentation. You might want to gather more evidence if necessary. If for some reason you have reason to believe that the event didn't actually occur, you might want to gather some more evidence, evidence that the employee lost coverage or evidence that the employee actually got divorced if you're not quite sure if the event happened or not. Then you also want to make sure that the employee has requested the change within the given time frame. Generally, that time frame is outlined in the plan documents. Normally, most plans require notice from the employee within 30 or 60 days of the event. That's generally the typical time frame that is required by the plan. If any more time than 30 or 60 days passes, then there's a question as to whether the employee is making a change on account of that life event. So you just want to make sure that you're following the plan rules in terms of when the employee requested to make the change. Also, you want to verify that the insurance carrier will actually allow such a change. There could be issues with your insurance contract, and many of you know that medical insurance carriers have become more restrictive about the changes they will allow to coverage recently. So it just might be a good idea to check with the carrier to let them know the change that has happened and make sure a change can happen and that they will allow that particular change. And then finally, the last thing you want to do is determine when the change will become effective. The general rule, the IRS requires that most changes will be effective from the date it is requested. So if a change is requested 15 days after the event happens, the change will go into effect on the day that the change is effective. There is one small exception. Retroactive changes are permitted in some rare circumstances. The most common of those circumstances is a HIPAA special enrollment rights for the acquisition of a dependent by birth or adoption. In that scenario, oftentimes the employee can request coverage be effective back to the date of the event. So that's just a brief description of the analysis that you might want to go through if an employee comes to you and asks if a qualifying event has occurred. Just to summarize, qualifying events allow employees to make a mid-year change to their 125 election. It's the three major requirements that we talked about are that a qualifying event has actually occurred, and we've put up the common qualifying events. Second, the change requested must be consistent with the qualifying event. And finally, the plan's legal documents must permit the change. So that is a very brief qualifying events 101 discussion. Obviously, if you have any questions, Christopher@ProBenefits.com is my email. I can assist you if you have more in-depth questions. You can also contact your ProBenefits administrator if you are a client. And so that basically wraps up our mini webinar today. Again, if you joined us late, you can submit questions in writing on the right hand, and we will answer those in writing. This was a new format that we debuted, 15 minutes, a 15-minute mini webinar on a specific compliance topic, and so we'd love to hear your feedback as well on this particular format. But again, that wraps up our discussion for today. Our webinar schedule is being finalized and will be posted on our website as soon as we finalize it, but there will be a February session. So look out for the invitation for the February session. I believe it's going to be a discussion about HSAs. So look out for that invitation probably early in February. But again, thank you for joining us today. Any questions that have been submitted, we will answer in writing, and have a good day. Thank you.